Hello and welcome to the Sidebar, presented by True Crime News, taking you inside the courtrooms of high-profile and notorious cases from across the country. I'm your host, Joshua Ritter. I'm a criminal defense lawyer based in Los Angeles and previously an LA County prosecutor for a decade. You can find me on all social media at Joshua Ritter ESQ or at joshuaritter.com. We're recording this on Wednesday, November 6th, 2024. In this week's episode, a man accused of his wife's murder is now facing additional charges after allegedly going to extreme lengths to draw attention away from himself. Plus, a pastor raided by the FBI months after his wife was found dead, leading many to wonder if the wife's passing was the result of foul play. But first, a surprising turn in the RICO prosecution of rapper Young Thug as the defendant at the center of Georgia's longest-running criminal trial agrees to a plea deal. Today, we are joined by Philip Dubé, a public defender, media commentator, and legal analyst you can catch on Scripps News, News Nation, and Court TV, among many other outlets. Philip, welcome.
How are you there?
I'm very, very good. And I'm very excited that we were finally able to get you to come on our show here because I see you on Court TV and other outlets quite a bit. And I'm always impressed because I feel like you're one of the more well-researched commentators on these cases. It shows in your comments that you know what you're talking about, if that makes sense.
Oh, I appreciate that. Well, Look, I think one of the reasons why I started doing this is because there are a lot of legal pundits out there who really don't know what they're talking about. They just spout off general principles that don't really apply to the case, and not to mention that they misstate the law. And it became kind of a pet peeve of mine. I thought, I can do this and state the law accurately, So that's what I'm trying to do. Yeah.
You're a crusader. You're a commentator, but you're also a crusader. So I appreciate that. Well, then let's jump right into these cases. First, out of Atlanta, Georgia, after nearly 2 years of court proceedings, the RICO trial of a Grammy Award-winning rapper has ended in a plea deal, closing the main chapter and the legal saga of Georgia's longest-running criminal trial. Rapper Young Thug, born Jeffrey Williams, agreed to the blind plea deal as the criminal case facing the rapper again suffered a prosecutorial blunder, opening the door for a mistrial. While Williams pleaded guilty to the charges without a deal in place, the legal gamble paid off, with Williams avoiding additional jail time in favor of 15 years probation. The trial, which has been fraught with difficulties and delays since the beginning of the proceedings, faced yet another setback prior to the agreement that could have halted the case entirely. The latest issue came during state testimony in which prosecutors gave a witness unredacted social media posts to read in front of the jury. These documents revealed that 2 co-defendants in the trial were in jail, a detail that was deemed too prejudicial for the evidence to be presented unredacted. Judge Paige Whitaker considered the misstep to be a significant enough violation to consider a mistrial, paving the way for the state and Williams' defense to agree on a plea deal. Williams heavily considered his options before entering the blind plea, which many of his supporters and family members urging him to continue the trial to conclusion. Though Williams did not receive a prison sentence, he could spend 20 years behind bars if he fails to meet the requirements of his probation. Philip, this case has been going on for so long, and it's taken so many twists and turns, and so many times I feel like it was on the brink of a mistrial. Are you surprised at this ultimate end, at least for Young Thug, in this plea deal?
Not at all. In fact, I thought the judge was fed up, frankly. I don't know how many judges they've had on the case. And, to be fair to the prosecution, I don't think they did anything intentionally. I think they were in over their heads. They got a little sloppy and slipshod in their presentation of the evidence. But one of the biggest no-nos is prosecutors can never comment on excluded evidence. It's so prejudicial. It's an ethical violation. And sometimes the only way to cure it really is to declare a mistrial. Just simply telling a jury to ignore it, disregard it, pretend like you never saw it is like asking them to unring a bell, that old adage. And it's just not realistic. And it was so prejudicial to make reference to and to perhaps see people on trial dressed in county jumpsuits. There's just an implication of guilt when they're sitting there fighting for their lives, only to be subjected to this sort of incriminating type outfit. So, yeah, I think the judge was absolutely correct in kind of goading both sides into reaching resolution. And if they couldn't, the judge was going to make the correction. The judge was going to offer a sweet deal to the defendant as an incentive to end this matter and avoid a retrial. I got to tell you, this has taken longer than most probates, Josh. I mean, imagine having a family member die without a will. It takes forever to get it through probate, for all the beneficiaries to get their assets and their the gifts from the estate. This is how long it's taking. And that poor jury is sitting there under insufferable conditions. I can't imagine it. I just can't.
I agree with you, especially when it comes to the jury. I'm shocked they were able to keep a jury this long, not just because of the length of the trial, but with all of the delays. I mean, they took weeks off when there was this whole kerfuffle involving the judge. And then they call these people back in and tell them, oh, here's a brand new judge, by the way, and we're going to redo some of the testimony in the meantime. I can't, the long suffering attitude of these people is just amazing to me, that they were able to stick around this long to see at least all but two of the defendants finally see a conclusion here. Now, I want to get back to a point you made about you don't think the prosecution did this on purpose. Yeah. I agree with you. It may not have been on purpose, but you make enough mistakes and you begin to wonder, are these unforced errors or perhaps something else? I'll put that aside for right now. But I want you, if you can, explain for our viewers and listeners this idea of a blind plea deal. That's what they keep referring to this as.
Yeah, out here in California, or at least in LA County, sometimes we call it an open plea. Or sometimes we ask the court to give our client what we refer to as an indicated sentence. And what that means is the court disregards any offers of disposition from prosecutors, and the judges review the case independently. You give the court permission to read the police reports, to rely on any testimony that may have been given, read preliminary hearing transcripts, or if there's a grand jury indictment, read the true bill, all of it. And of course, look at a defendant's criminal past. And sometimes courts do the right thing. They don't always agree with prosecutors, and there's no reason why a defendant should be put on trial, particularly if they don't even want one. Sometimes the only reason why they're going to trial is because their only option is to take life in prison in this situation. And I think the judge, in her kind of King Solomon wisdom, gave the defense the winky wink that if you plead open to me under a blind plea agreement, your client's going home. Yeah. And it was too sweet of a deal to pass up. And frankly, I've done it many times over the years. Certainly, you have to know the tendencies, the predilections, and the mindset of your judge to know that they're not going to hurt your client. Because in theory, this judge could have sentenced him to life in prison. She really could have. She could have said, I appreciate the plea. I appreciate your patience. I appreciate the fact that you've all tried to settle the case, but this young man's life is over. And I accept the plea, I adjudicate you guilty, and off you go. How many days credit does he have? But she didn't do that here. And I think the reason why is fairness dictated a much juster outcome. There were too many incurable errors, and I call them errors and blunders. I don't want to say that they were willful or intentional, to say that this guy could get a fair trial and finally bring some finality to this matter. And I think the judge did the right thing. The only thing I question is whether or not it might be the devil's bargain. Because when you think about it, he's going to be on probation for 15 years. It's a
long time. Yeah. That's a very long time. And I'm glad you brought that up, because I want to get back to that, because you don't usually see probations of that long, at least not where we both practice. You don't see that. But I'm glad you brought this up about the way it has been characterized in the media a lot, is that it was almost like this act of faith on the part of Williams and his attorneys, that they're just, Your Honor, we throw ourselves at your mercy and do with us what you will. But I think there was much more of what you characterize as kind of wink nod going on, where they said, Your Honor, this is the people's offer, which includes an additional 5 years of prison for my client. can you do better? And when she came back with, I'm going to put him on probation for an extremely long time, but he's going home, they said, well, then we would like to plead open or plead blind. And that's what the media ran with. But I am sure he did not go into that without knowing what was going to happen. Do you agree?
Oh, of course. I'm sure his attorneys told him, first of all, when you leave here today, you will be a felon. You're going to be, and additionally, we say in the law, he had to plead to the sheet, meaning all the charges that were in the, I don't know, I can't remember if he was indicted or if the prosecution just directly filed charges on him, but all the multiple counts were part of that plea agreement. So he is a multi-count felon. Now, for you and me, Josh, we don't want to go through life being stigmatized and branded a felon, because sometimes that's worse than even doing time, frankly. The thought of everybody looking at you, we're respectable attorneys in our trade, and now everybody knows that we have a felony. Sometimes that is worse than actually doing time. In his particular situation, he just didn't want to go into custody because he had 6 children. He wanted finality. And let's be honest, I'm sure this defense didn't come cheap. I'm sure this was costing him a bloody fortune. I don't know what the young man was worth, but let me tell you, these 2 attorneys, I don't know them, but they don't work for free.
Well, whatever he's worth, he's certainly not making more of it the more time he spends in custody. I mean, he needs to get out and start working. And I imagine we'll start seeing albums released on the quick to pay for some of those attorneys' fees. But let's talk a little bit about the length of this probation, because I agree with you. I've been offered situations where they offer a large amount of probation with what we call suspended time as well, meaning if he violates, he's getting 20 years prison. That is an incredible sword to have hanging over your head for the next 15 years of your life. Now, walk us through how that actually works. Does that mean he gets a jaywalking ticket and all of a sudden he's going to prison for 20 years?
No. One of the terms of probation, and that's what he's getting, is a grant of probation. Basically, what was it, for 20 years or 15 years? He has to obey all criminal laws. That's the gist of it. He doesn't have to obey all civil laws. In other words, you're not going to ever be held in violation of your criminal case for breaching a contract or for defamation or for causing a slip and fall in a supermarket. I mean, those are civil matters, But if you commit a crime, and you are convicted of that, that will be brought to the court's attention, and the court can set the matter on for a violation hearing. And you're entitled to due process at that hearing, but you do not get a jury. Only the judge gets to hear that evidence. And the standard to violate is just a preponderance of the evidence. In other words, that it was more likely than not that he or she committed this additional offense while on probation, as opposed to proof beyond a reasonable doubt. And that standard is low. And I got to tell you, it's extraordinarily rare in the case law for a violation finding to get reversed. There is great deference to trial courts in finding a violation just based on a balance and a review of the evidence. Because in the end, it's usually a credibility call, or sometimes it's a question of law. But the bottom line is this young man's going to have to watch his back for the next 15 to 20 years and make sure he doesn't get into any fights, that he certainly doesn't have any firearms on him, that he's not driving on a suspended license or picks up a DUI, because that could be his ticket back to custody.
Absolutely. Yeah, he's really going to have to make a huge lifestyle change. He gets out and he may be out and never go back again. But you're right. He has got a very short leash, and they will throw the book at him if he does anything close to the nonsense that was alleged against him in this case altogether. But I think, end of the day, in its overall view, you got to view this as a win for the defense, that they were able to stick it out, wear them down, and really push the judge to the point where she was able to make this kind of a plea, like you said, bypassing the prosecution. So pretty incredible outcome for young Thug. But we will, like I said, it's still a case where there are a couple of remaining defendants. We'll keep an eye on that and see how many more records they break in Georgia as far as how long this trial will take. Let's move to Myrtle Beach, South Carolina, where months after the death of a pastor's wife was deemed a suicide, FBI agents raided the South Carolina man's home, further fueling speculation that the man of the cloth had a hand in his wife's passing. Mika Miller was found dead in a state park in April of this year, with some family members believing she was the victim of foul play and accusing her husband, John Paul Miller, of having a role in the woman's death. Authorities have disputed this narrative, maintaining that the gunshot wound that ended Miller's life was self-inflicted. Mr. Miller, the pastor of Solid Rock Church, was estranged from his wife when she died, and the woman had filed for separation just over a week before her tragic demise. Despite clearing Mr. Miller as a suspect, investigators have announced that the man is the subject of a, quote, parallel investigation that is reportedly not related to his wife's death. The FBI has not released any specifics on the investigation, telling media outlets only that the agency was engaging in court-authorized law enforcement activity at Miller's home. As this case develops, we will continue to update you with any breaking news. What do you think, Philip, is going on here? I mean, it is the part that's bizarre to me is you have this case that a lot of people were speculating about it. A lot of people online, it really caught fire as far as the circumstances of her alleged demise and his, possible involvement. And it's not so much that the FBI is doing this, but that they're not really giving much information to people that is causing issues. What do you think's going on?
I think this parallel investigation is a probe into financial crimes. It's just my hunch. We saw this in history with Al Capone. We saw it with Sammy the Bull Gravano in history, where they couldn't get him on the violent stuff. They couldn't get him on the mob hits, but they could certainly get him on the tax stuff, the tax evasion, which, by the way, carries hard time. And if I recall correctly, after they raided the house, they were carrying boxes of stuff out of that house, and I'm pretty confident they weren't body parts in those boxes. They were probably financial records, stuff from a computer. I have a feeling that they are investigating him for some type of financial impropriety, and we'll find out soon. You can bet they're going to get a forensic auditor to look at everything to see if there was any shortfalls, any income that didn't get reported, or perhaps any misappropriation from funds, or stuff that shouldn't, or that was declared that should not have been declared. And that's how they'll typically get them. And it's just a guess. But when you have a parallel investigation to a homicide that's not directly related to the homicide, the only thing that comes to mind is that it's a paper case.
That's what's funny to me about this is they called it a parallel investigation. And that's such a interesting choice of words there, because you would think they would say unrelated investigation, but calling it parallel makes you start to wonder, okay, well, if it's not her actual murder, then how could these, and I agree with you, if it is a financial thing, how could that be parallel to her death? Do you see where I'm going?
I think, correct me if I'm wrong, what was it, a week or two before she disappeared and succumbed to her self-inflicted gunshot wound, there was either a separation or a divorce pending, that the marriage was on the rocks. They were in the process of parting ways. Well, that necessarily means a division of marital property. And that is the classic motive in most marital homicide situations, where you have the wife or the husband who gets killed. The question is, why would they want out? Well, it could cost them a bloody fortune to get out of it once the marriage is over. So they try to find a workaround, if you will. Well, in this particular case, there really was no obvious workaround, because it was clear from the evidence that it was a suicide. But I think tips, clues, leads may have shown that he had a financial motive or a financial reason for not needing her or wanting her around anymore. And I think it may have prompted a paper investigation. And it's just a hunch. I have no evidence to support it. It's just sort of in primal clues, if you will. And it's not uncommon, So we will probably know in the next couple of months if the walls are closing in on him.
Yeah, I agree with you. And to add to the gossip mill with my own unsupported hunch, I wonder too if what could have played a role in bringing this poor young woman to the decision, that the tragic decision that she made, was not only the idea that she was losing her marriage, but perhaps she knew about financial misdeeds and knew that those would be exposed. And that could have also fueled her feeling of despair. I don't know. Again, we're all just reading the tea leaves here because they're not sharing much information with us, but it is one of those cases that a lot of people seem to be very interested in. But end of the day, you're right. All we're doing here is having a fun game of, pin the tail. And until they actually release more information about it, we're just playing games. So we'll wait. We'll be patient. Just
remember one thing, Josh, and that is they got a warrant. That means they swore out facts in an affidavit of probable cause that gave a judge pause to sign off on that warrant. So obviously there was some evidence rising to the level of probable cause that there was evidence of criminality, enough for a magistrate to sign off. So it'll be interesting to see what they got on him.
You're absolutely right. As much as they would like to, law enforcement still cannot say, I'm just curious, and get a judge to sign a warrant. Right. So there had to have been something at least there to support it.
And I cannot tell you how many times I've seen law enforcement come in with their little packet of documents and their little police reports looking for the magistrate of the day to sign off on the warrant. And 15 minutes later, they come out of chambers gnashing their teeth because the judge wouldn't sign the warrant. They were told, go out in the field, pound the pavement, beat the bushes, get me more evidence. Well, apparently 100%. In the first go around, they got the goods.
Yeah. Even if we saw the affidavit alone, that would probably give us a real glimpse into what's going on. But we'll be patient. Let's move to Gaston County, North Carolina, where court documents allege that a man accused of his wife's murder went to extreme lengths to hide the killing, including setting fire to a medical helicopter, faking his kidnapping, and even poisoning his own daughter to cover his tracks. Joshua Hunsucker is charged with the murder of Stacy Robinson Hunsucker, who passed away in September of 2018. Immediately following the death, Hunsucker collected $250,000 from a life insurance payout and promptly had his wife's body cremated. Unfortunately for the alleged killer, Stacy was an organ donor, which necessitated keeping a sample of her blood on file. When the blood tested positive for tetrahydrozoline, Hunsucker became the focus of a murder investigation. Prosecutors say that Hunsucker's behavior became increasingly erratic as investigators closed in on the man, culminating in the alleged poisoning of his own daughter with eye drops. Fortunately, the child was taken to the hospital after suffering extreme exhaustion due to a low heart rate and constricted blood vessels, side effects of potential tetrahydrozoline poisoning. Hunsucker appeared in court this week for a bond hearing. However, instead of gaining his freedom, his original bond was revoked due to the additional charges related to the alleged poisoning of his daughter. The father maintains his innocence in all charges and is expected to face trial in the fall of 2025. Philip, this case is incredible to me because that one little twist seems like something out of a movie plot. That the idea that if it wasn't for the fact that she was an organ donor, this may have been the perfect murder, right? She dies, no autopsy is performed, no one really investigates it, but she happens to be an organ donor. That one thing he missed, and because of that, they're able to test her blood and find this poison, these eye drops inside of her blood. What putting that, appreciating that for a moment, what in the world is going on with autopsies? Why in a situation like this where somebody dies, obviously not of old age, put it that way, why aren't they ordering a autopsy in a situation like this?
Well, first of all, every jurisdiction defines what's called a suspicious death. If a doctor or a paramedic or whoever finds the human remains or the decedent doesn't suspect a homicide and there's nothing on its face to lead you to that conclusion, then the body just gets released to the next of kin to a mortuary. And certainly if somebody dies in the hospital, the body remains in the morgue of the basement, in the basement of the hospital until the mortuary comes and picks up the remains. So at that point, all you're really doing is having a doctor sign off on the death certificate. And I think on its face, it probably read cardiac arrest heart failure, heart attack. Well, of course, but it was drug induced. Yes,
Right.
ultimately her heart failed, but why? Yeah, well, it's because she was pumped full of tetrahydrozoline. That's why. So then, it prompted this investigation of where it came from. And if I recall correctly, didn't they find some of this stuff in his truck or in his home?
If they had just cremated her without an autopsy and without any kind of blood sample, then what have they got, right?
Oh.
I mean, it's a far more difficult case for them at that point.
That's a great question. And there is a branch of forensics now where they can test cremains for poisons. If they can actually get a hold of those ashes, they can go to the lab. Don't ask me what kind of machine that they use. I can't even remember the name of this huge device that they use that will literally break down the ashes to its lowest common denominator and look for various chemicals. And I've seen it done where they've actually found drugs and poison in cremains. It's not uncommon, but they've got to get a hold of those ashes in order to do the test, And oftentimes it requires a warrant to get the ashes. And sometimes there's not enough probable cause to get the ashes. Sometimes the ashes are interred in the ground. The urn actually gets buried. But in order to exhume that, you need a warrant or a consent from the family. And if you don't have that, it'll go unsolved.
Yeah. Well, and I don't know what happened here, but in my movie plot scenario, he spread those ashes over the ocean and they were never recovered. So I guess I'm still stuck on this point that, I appreciate you walking us through that whole thing about what is a suspicious death. And, they cannot obviously perform an autopsy on every person who dies. I completely understand that. But you would think like you said, somebody dies before their time. It's kind of like there doesn't appear to be any kind of prior medical issues. Take some blood. Do a quick test. Just rule out some perhaps maybe very obvious things. Like you said, drug induced, even if it wasn't tetrahydrozoline, maybe it could have been something else that would have given them some more insight. It's just amazing to me how close this was to being unsolved.
Even if they would have done that, let's just give them that. Let's say you had a really thorough medical examiner who maybe even suspected some type of drug overdose. There is a standard toxicological screen that they do in most coroner offices across the country where they do a basic drug screen of 100 different controlled substances. I sincerely doubt that tetrahydrozoline is on that list. So they look for, your basic illicit street drugs. They look for certain, antipsychotics that may have caused it. But stuff like Visine, or nasal spray, they can't look for every conceivable over-the-counter type med. So I think even if they would have done that, it would have come up negative unless they were specifically looking for that drug.
Yeah. No, you make an excellent point. And that's something that a lot of people don't understand is that when they do a toxicology, they have to be looking for that thing. It's not just tell me what's in this blood and it reads out every substance in there. They have to, does it have a narcotic? Does it have an opioid? Does it have a cannabinoid? And be looking for these things. Very, very good point. Just a crazy case. We'll continue to follow it because it just, again, fascinates me. And we do see this, it seems to be this new string of tetrahydrozoline poisonings. I just wanted the excuse to say that word one more time, but it does seem like that is the poison du jour of a lot of people attempting to murder their loved ones. But we will leave it there for now. That is our show for this week. Philip, it has been such a pleasure to have you on. Where can people find out more about you?
Oh, you can go to my Twitter, X, Philip C. Dubé. You can follow me on Facebook. You can follow me on Instagram, or you can shoot me an email at philipdubé@aol.com. I'm a dinosaur.
Fantastic. I hope you get some emails. I am your host, Josh Ritter. You can find me on Instagram and Twitter at Joshua Ritter ESQ. And if you want to hear my thoughts and coverage on even more true crime cases, you can also check out my brand new YouTube channel, Courtroom Confidential. And you can, of course, always find all of our Sidebar episodes wherever you get your podcasts. And we want to hear from you. If you've got questions or comments you would like us to address, tweet us your questions with the hashtag TCN Sidebar. And thank you again for joining us at the True Crime News Sidebar.